the Associate Dean for Environmental Law at George Washington University Law School, and happy to be here moderating this panel today. As many of you know, citizen science is an area that has been rapidly growing over the last several years. It's especially important, in my view, in the environmental context where monitoring in the air quality, water quality, and other areas, there are large gaps in knowledge, and the ability of handheld and other types of monitoring and citizen involvement can be especially important. I think that's true, perhaps most importantly, in the area of environmental justice, where monitoring localized emissions in communities can make a significant difference in health outcomes. So our panel today will focus on how can environmental monitoring initiatives fully harness the power of concerned citizens in the US and around the world, and which laws consider and foster the engagement of citizens in the enforcement of environmental law, and how can these laws be better implemented to educate and motivate citizens while protecting them from retaliation. This is a topic of particular interest to me. I've followed technology issues in the environment for more than a decade, and along with George Wyeth, who is a visiting scholar here at ELI, Rob Glicksman, who teaches at George Washington, Allison Parker, who was at EPA, but now is in the citizen science program at Woodrow Wilson, and one of our students, Jacolia Williams, recently published an article in Environmental Law Reporter News and Analysis on the impact of citizen environmental science in the US, where we looked at some of the new technology available for citizen monitoring and at 10 case studies on how citizen groups were using these technologies. And I think we're finding this is a rapidly changing world, and I think our panel today will help us all understand both some of the opportunities and challenges in this field. I'll introduce our panelists one at a time. We have one here live, and the other two will be joining us remotely. So our first panel member is John Kostiak. He's Executive Director of the National Whistleblower Center. Before arriving at the National Whistleblower Center, John served for 4.5 years as Executive Director of the Wind Solar Alliance. And from 1994 to 2014, he was at the National Wildlife Federation in a variety of roles, culminating in his role as Vice President of Wildlife Conservation, where he managed NWS wildlife and habitat conservation efforts. With that, I'll turn the floor over to you, John.
Thank you, Lee, and thanks to my friends at Environmental Law Institute and INES for co-sponsoring this series of webinars with the National Whistleblower Center. For those who don't know the National Whistleblower Center, we are a 31-year-old nonprofit based here in Washington, D.C., protects people and the environment from corruption by doing three things: providing legal assistance. Let me just get to the right slide here. There you go. Providing legal assistance to whistleblowers, strengthening whistleblower policy, and educating the public about the benefits of whistleblowers. And today's topic is really right in our wheelhouse. We're all about helping everyday citizens and very much like to help citizens protect their environment. So this will give you a little bit of a preview of what I hope to talk about today. I want to start with the critically endangered porpoise known as the vaquita. It's really a fitting symbol of what we're up against. The forces that are driving this beautiful animal to extinction in its home in the Gulf of California are the same forces that are driving much of the environmental devastation around the world. And those are the forces of crime. One of the biggest environmental problems we have is that environmental crime is highly profitable, especially when there is an absence of meaningful law enforcement. Here, the crime is that of blanketing the Gulf of Mexico with fishing nets and trafficking in the totoba, which is a fish whose bladder is greatly prized in the Chinese medicinal market, and therefore it is an extremely lucrative business. So the key point I want to make is that many of the tools that we in the conservation community know about don't really work in this context. Persuasion, economic incentives. This is the world of conservation for many people. But for gangsters like this guy right here, the Mexican cartel leader, Oscar Parra, whose cartel has been devastating the Gulf of Mexico, Gulf of California with fishing nets, persuasion, economic incentives are meaningless. They won't stop folks like him. They won't stop folks who commit crimes from corporate suites, the ones who wear the suits and every day and carry out corrupt activities on behalf of certain multinational companies. So the question for us to think about today is, have we used every tool in our arsenal for pursuing these criminals? And a little bit of a preview, we're not just talking here about environmental crime. And therefore, we shouldn't just be talking about enforcing environmental laws. Parra was ultimately thrown in jail for murder, not illegal fishing. So this is an area of the Amazon rainforest under serious pressure from ranching and farming. Many people believe that the best hope for keeping this forest intact and rescuing our global climate and providing many important services to local communities is to engage rubber tappers and others who are focused on sustainable extractive uses. But here's the problem. Low impact activities like this are increasingly impractical because the local residents say, this is not me saying, local residents say they're being terrorized by criminals. Rubber tappers cannot survive if criminals are leveling their forests, just like subsistence fishermen and women cannot survive in Mexico if criminals are destroying the fisheries. Many of you might know this gentleman, Chico Mendes, the rubber tapper and lands rights activist who really conceived of the idea of an extractive reserve. He's a whistleblower and a hero who paid with his life for his advocacy. Assassinated by a rancher in 1988, the rancher was essentially trying to shut down the movement that Chico launched. Well, fortunately, the movement continues. But the question I want to ask today is, have we learned how to provide better support and security for our environmental heroes? So there are a lot of choices here about where to focus. My organization right now is focusing on 4 areas of environmental work because they are rife with corruption and very much in need of aggressive law enforcement. Let me just give a couple of numbers to put these problems in context. 20% of our wild-caught ocean fish are estimated to be illegally caught. That is a lot of fish. 10 to 30% of the global wood trade is estimated to be comprised of illegally harvested forest products. So let's say we all agree it's time to give greater focus to crime in our environmental work. Where to begin? Well, I would say I tend to look at most environmental issues from a global perspective, and I would strongly encourage us all to think about how to increase international cooperation. But international laws, that's a different story. They don't provide enforcement tools. So we need domestic criminal laws and civil penalties, particularly those that have a track record, the ones that are already working. The good news is the United States has a host of laws that are indeed successful in this area. And this includes laws that are designed to address global problems, such as the Endangered Species Act, a law I've spent a fair amount of my career working on, enforces the CITES Convention on wildlife trafficking, and the Act to Prevent Pollution from Ships, which enforces the MARPOL Convention. Now, the natural starting place for many people in the environmental community is the so-called citizen suit provisions. In fact, if I were to tell people I was giving a talk about citizen enforcement, oh, you're going to talk about the Clean Water Act, Clean Air Act, Safe Drinking Water Act, citizen suit provisions. And the answer is no, that's not what I'm here to talk about. I love these laws. I used to enforce them in a prior life, but they will only play a small role, in my view, in tackling the big global challenges we face. They focus mainly on environmental injuries experience inside the United States. And then really not designed to help build criminal cases. Only occasionally in these cases do the plaintiffs even ally themselves with the government to prosecute. Usually the government is the defendant. And even then, when there is the environmentalists lining up with the government, there's no incentives really for the citizen environmentalists to cooperate with the government in building a case. Let's talk in contrast about whistleblower laws. Key feature of the key TAM whistleblower laws is that exact incentive I was alluding to. Citizens are incentivized with financial rewards to cooperate with the government in building cases. Lacey Act, Endangered Species Act. Under those laws, whistleblowers receive rewards from Interior Department, Commerce Department, Agricultural Department for helping tackle illegal trafficking in wildlife, fish, and plants. Act to prevent pollution from ships. Rewards from the Coast Guard for bringing forward evidence of illegal discharges from ocean vessels. The Whistleblower Center is involved in enforcing these environmental laws. We're also involved in this second body of laws, False Claims Act, Dodd-Frank Act, host of non-environmental laws, and we're using them to pursue environmental goals. I'm going to get back to those non-environmental laws in a moment. Let me just show a couple pictures. Carnival Cruise Lines. I don't know if you've all been reading the news about Carnival Cruise Lines lately. They just settled a second criminal case, very much similar to the first criminal case, rampant dumping in our oceans and coastal waters. This case was developed thanks to the cooperation and help of whistleblowers. $60 million penalty is now accumulated. Let's hope that begins to change the corporate culture. If not, we'll go in again. But that's just a classic case of how whistleblowers can truly make a difference. Whistleblowers helped put this case together. It was smuggling of jaguars out of Mexico into the United States, ultimately, presumably to serve the Asian market. There's status symbols, apparently, of the fangs and the furs. But this was a very significant case that only came about thanks to whistleblowers who were rewarded. All right, I want to focus my attention on some of these non-environmental laws. Let me just focus primarily on the False Claims Act. There's a whole bunch of environmental laws, non-environmental laws that we could talk about, but due to the limits of time, let me just give a little bit of focus to what I would consider to be the most important, many people say is the most important of the whistleblower laws. And here's why. I'm not going to read all those bullets for you. Hopefully you'll have a chance to take a look at them in your own time. But what I want to focus on is the fact, well, first of all, this law has been around a long time, so we have a lot of great experience with it. Originally signed by Abraham Lincoln, modernized in 1986. So we have a nice track record to look at, and what we have learned is that the government loves these cases. And that's really important for building cases. You want support from law enforcement officials. And they love these cases because it has treble damages, and that produces big penalties for criminals and big returns for taxpayers. Whistleblowers love this law. They can file a case confidentially under seal. The government will often do the heavy lifting, essentially all the work on the litigation. And then there's that mandatory reward. 15 to 30% of the government's recovery goes back to the whistleblower. This gives you a flavor of some of the numbers we're talking about. $42 billion to the US Treasury thanks to whistleblower cases. And that's $6.4 billion with a B into the pockets of whistleblowers, thanks to their helping build these cases. All right, let's talk about how we might use this law for our environmental purposes, getting citizens engaged. There are two types of cases. One, where the corrupt individual or company collects money from the government that was not properly earned. And that's really what gave rise to the original law back in Civil War times. Civil War contractors were bilking the government. But then there's the Reverse False Claims Act case, and that's where somebody withholds money from the government that should have been paid. That covers a lot of potential environmental wrongdoing, including, for example, misleading statements made by an oil and gas company in its application for use of our public lands or waters, or false custom declarations by a seafood company or a wood products company. So the Whistleblower Center has an important wildlife case filed under seal using this Reverse False Claims Act approach. You might remember this big environmental case known as the Deepwater Horizon, $20 billion settlement, record recovery. Well, there was in that case a False Claims Act claim made by the government. It was actually a Whistleblower Center that alerted the government there were some significant False Claims Act violations. To give you a flavor, BP said it had relied on a top wildlife expert when it prepared its response plan. It failed to mention that expert had died 4 years before the preparation of that response plan, the submission of that response plan. So there was a bunch of misrepresentations about safety and emergency response procedures that enabled the government to use the False Claims Act as part of its arsenal in that case against BP, and as part of the criminal settlement. Let's look at this from the NGO perspective. You're an NGO, you want to get involved in whistleblower work. We really recommend thinking about this from a strategic communications perspective. Let's talk first about behind the scenes communications. Non-governmental organizations often have deep roots in communities where the witnesses to crimes reside. Oftentimes they'll have strong relationships with law enforcement officials. Both of these play a critical role, enable the NGO to serve as a bridge to prosecutors as well as private attorneys who represent whistleblowers, and facilitating that critical behind the scenes communications. And we'll talk more about what that might look like from a technology perspective, I hope, today. But NGOs can also help with public communications, whether it's playing up the revenue benefits of a prosecution. Oftentimes these cases have big national security implications. We were just talking before we got started about the linkages between wildlife trafficking and trafficking in wood products and terrorism and human rights violations. So there's a lot of work to be done to build support for these cases, both among the prosecutors to motivate law enforcement officials to proceed and think big, think much bigger than they have been up till now, as well as to the policymakers whose support we need to keep these laws intact, as well as to continue strengthening these laws. And I would also emphasize, and I know as a lawyer this sounds self-serving, biased, NGOs should be connecting whistleblowers with qualified attorneys, because navigating through these cases is not a simple matter. This is a specialized area of law, not well suited at all for whistleblowers to take a go-it-alone approach. It's something that the Whistleblower Center puts a lot of effort into. We have a confidential legal intake system. If you go to our website, click on Stop Fraud, you'll get a sense of what that looks like. Another thing that NGOs and all of us should be involved is educating whistleblowers. We know we cannot completely eliminate the risk of stepping forward with evidence of environmental crimes, but we also know there's much more we could be doing on minimizing that risk. Any decision on whether to step forward should include a discussion of risk minimization, and that includes how to maintain confidentiality and anonymity and how to ensure secure communications. This is often not part of the public conversation because the cases you know most about are the people who have decided to go public and are really not putting a lot of work into protecting themselves and leaving themselves pretty exposed. There are other ways to go to become a whistleblower, and that is to protect your anonymity. Now, that's not consistently the case for in implementing whistleblower laws. For example, the False Claims Act says that you can file the case under seal, remain anonymous, and the government will take a look at the case and decide whether or not to intervene. And if it decides to intervene, you remain anonymous and they take over all the litigation and you get rewarded for your contribution. Some of those contributions can be continuous throughout the course of the case. You remain anonymous, you can stay inside your company and deliver evidence to the government. But if the government elects not to pursue the case, you also have the option of proceeding on your own, and that requires disclosing your identity. So there's the complexities there of how to maintain confidentiality and anonymity. Some of these other laws, there's no provision for the whistleblower to proceed on their own. So they can stay confidential and anonymous the entire time, and the government decides whether to proceed. Another key area of risk that we need to do better in educating whistleblowers about is timeliness. Some of these whistleblower laws have first to file requirements. And so if you sit on your hands, somebody else could come in and maybe even take the information you gather and deliver it to the government and disqualify you from your reward. So a lot of fine points that require work from all of us to help whistleblowers proceed. Now, we are an organization whose core mission is helping whistleblowers. So I would really like to close here with a strong message about the importance of protecting whistleblowers. We talked earlier about Chico Mendez's death. We all know that this is a serious concern around the world, including in this country, but especially in countries with poor governance and poor law enforcement systems. There's no more important thing that we can do to show our support for whistleblowers is to educate them and ourselves about best practices, to keeping them safe from retaliation to the greatest degree possible. And that means using the attorney-client privilege wherever possible. It means taking advantage of encryption technology for any communications, thinking really carefully about how and whether to pursue your case through the media. Our view is that public disclosure should happen, but only if the whistleblower has given informed consent with full awareness of the risks and how to minimize them. Again, lives and livelihoods are often at stake. So I just want to wrap up and thank you all for listening. This is a really exciting time. Hope to keep all of you involved. We have a website we encourage you to go to. If you come to that section of our website, you can take action or at least stay engaged with our legal and policy programs. You can also order the Whistleblowers Handbook, written by Whistleblower Center founder and board chairman Steve Cohn. This is really well written. Despite being fairly thick, it's quite an easy read. I think it's really clearly written, and more importantly, these are the tools that we all need. So come to our website, get the books, get on our list, go to Facebook, go to Twitter, stay connected with us. Let's continue this conversation. Thanks.
Thanks, John. So we'll proceed with our second and third speaker. I expect we'll have substantial time for questions after our presentation. So our next speaker is Sean Goho, who is Deputy Director of the Emmett Environmental Law and Policy Clinic at Harvard Law School. With input from the Environmental Law Institute and the Environmental Defense Fund, clinic staff and students developed an interactive electronic manual for citizen scientists starting or participating in data collection and environmental monitoring projects. This interactive tool helps individuals and organizations identify, design, and implement citizen science projects, and is supported by a 50-state survey of trespass and other laws relevant to the activities of citizen scientists, and includes regulatory and evidentiary standards applicable to the uses of environmental data. And I might just point out that in some of our work on the citizen science paper we did, looking at data trespass laws was one of the important questions there, and the court's recent decision saying that data collection on public property is protected under the First Amendment. So with that, we'll turn the floor over to Sean.
Thank you. Let me just get my slide started. There we go. So my focus today is going to be more on the kind of traditional domestic environmental enforcement than what John was talking about. Really looking at the paradigm of a community group that is concerned about local pollution and is gathered together to collect some data about that pollution and are interested in enforcing violations of the environmental laws that they found. Now, citizen science can play multiple roles in enforcement. For example, the citizens can take the data they generated and they can go to EPA or to a state or local government agency, and then the government agency, after receiving that data, could then conduct its own investigation, its own data gathering, and then base a government enforcement action on that data. But what I want to talk about are instead some of the issues that are raised if the community group decides that it wants to bring its own enforcement action, whether it be a citizen suit or perhaps a tort lawsuit such as a nuisance suit, and what happens if they want to rely on their own citizen-generated data and bring that case. And so, these issues are ones that have not really been addressed in any great detail by the court. So my discussion today is going to be quite preliminary, really more a matter of identifying issues rather than providing answers to them. All right, so a brief introduction. One thing I just really want to make a plug for before I really get started is a new working group that's been created under the Citizen Science Association, a new law and policy focused working group, which might well be of interest to a lot of people listening today. This group has just been started up this spring, so there's really a chance to get involved at the ground floor. I really urge people who are interested in the intersection of citizen science and legal and policy issues to join us. We're really trying to come up with the focus of the group and the initial plans for action for the group. So the next slide has the URL for the working group, and so please do check it out and please do join the group. As the previous slide indicated, we really are interested both in the ways that citizen science can be used to influence law and policy, as well as interested in studying the laws and policies that affect the ability of citizens to conduct citizen science and then affect the ways in which citizen science can be used. This has already been covered in Leroy's introduction, so generally, but I'll just say that our clinic has been very interested in citizen science issues for the past couple of years, and the primary thing that we have done in that context is developed what we're referring to as our citizen science manual, and that citizen science manual is available online at the URL here, citizenscienceguide.com. There's a 50-state survey of laws relevant to citizen science, as well as information regarding literally all steps in developing a community-based environmental citizen science project. And we've also developed some supplements for that manual, including a supplement that deals specifically with some issues related to using citizen science data in litigation, which are some of the things that I'm going to talk about today. So there really are a number of issues that could potentially be relevant, so I'm just going to touch on a few of them. And these issues are listed on this slide, and I'll just jump right into them and then walk through them. The first one is Rule 11 certifications, which has to do with the attorneys needing to certify information that they're submitting, the factual basis for filings they're submitting in court. There's also their interrelated requirements of the rule against hearsay, and then the need to authenticate documents and data that are submitted to court. And then I'll talk about a couple of different distinctions between kinds of testimony and the rules that apply to them. So first is the distinction between fact testimony and opinion testimony, and then the second is really a subset of opinion testimony, what counts as expert testimony and what counts as lay opinion testimony. So first to talk about Rule 11, this is a requirement that's a matter of the federal rules of civil procedure. There are equivalent requirements in state courts. It's basically the requirement that anytime an attorney is filing a complaint or a pleading or a motion or other filing in court that relies on factual information, the attorney has to certify that there is evidentiary support for the factual contentions in that filing, and that means that they have to have reasonable confidence that the information underlying it is reliable. So in the context of citizen science, this really just means that the attorney must have a reasonable basis for believing that the citizen science data, is sound and provides a sound factual basis for the claim. So this is, it's a certification the attorney needs to make, subject to potential penalties from the court. So it's sort of a baseline requirement. If you're bringing in a case, you have to have some confidence in the reliability of the data that is the basis for your case. The next thing I want to talk about is rule against hearsay. The basic rule here is that hearsay is not admissible in court unless there is a relevant exception. Hearsay is defined as being a statement made outside of the testimony in court or in a court-related proceeding, and that it's a statement that the party is offering to prove the truth of the underlying matter asserted. The basic issue here for citizen scientists is that the records that they will have gathered of citizen science data are not on their own testimony in court. Plaintiffs will need to find a way to introduce that data in court, either to have someone testify about it, or to find, perhaps there would be an exception under which the records themselves could be admitted into court. So just to give an example of how these sorts of things could play out in practice, I'll just talk briefly about one case, one district court case. This case, Consolidated Environmental Management case, in the Eastern District of Louisiana a few years ago. It involved people who are making observations about opacity. So just the sort of how thick the dust is coming out off of a facility, how much it's blocking the light, and there is an EPA approved method for making observations and ranking how opaque the the emissions are from the facility. And in carrying out the observations, the people who made the observations filled out standardized forms. And so the question was whether these forms themselves could be admitted into court. And what the court held was, well, these forms were hearsay. They were, evidence from statements from outside of court, and they were being offered to prove the truth of the underlying matter asserted. And so the court said, these are hearsay. Generally, you would need to have someone who can testify about them, introduce them into court. And the plaintiffs did try to argue that they were admissible under a couple of exceptions to the rule against hearsay. The exceptions referred to as the business records rule, and then what's called the present sense impression rule, which has to do with the idea that people sort of just sort of blurt out at the moment they see something, what it is they're seeing, that's sort of inherently more reliable. The people are less likely to be calculating what they say. And the court rejected both of those because it said that these records were things that were consciously being made in contemplation of litigation and therefore weren't subject to those exceptions. Relatedly, I see it sort of being a complementary requirement to the rule against hearsay is that if you are going to introduce a document or other information and evidence, you need to authenticate that it is what you say it is. And so, the combination of the two, and I'm sorry about the slides here, somehow the fonts got changed from the version that I submitted so that they're cut off. I will resubmit my slides. The version I have, it doesn't, the text doesn't look like this. So I don't know what happened in the translation, but I hope I'll resubmit them so it'll be easier to read. The basic lesson here is that, litigants need a witness who can testify about the methods and records used for data collection, that those methods and records on their own aren't, sufficient evidence. Next, I want to talk about the two related issues regarding types of testimony. And I have sort of a partial, it's not the entire diagram, but a part of a diagram that we include in our supplement on citizen science litigation issues to our manual that sort of lays out the hierarchy. And the basic distinction, as I alluded to before, is that first you have distinction between fact testimony and opinion testimony, and then as a subset of opinion testimony, you have a distinction between lay testimony and expert testimony. And so I'm going to talk through the relevance of some of those issues for citizen science data. So first, on the question of fact versus opinion testimony, the basic idea is that expert testimony is a subset of opinion testimony. So therefore, if what you're offering is just fact testimony, then you don't have to be qualified as an expert to offer that testimony. And the general distinction, the way this is described is that, fact testimony doesn't involve any inferences or assumptions about facts, whereas opinion testimony, does involve inferences that you're drawing from facts. Now, courts have indicated as a practical matter, this can sometimes be a line that's very hard to draw. I have a quote there from a state court case. And, because generally speaking, almost any time you're describing something you've observed, there are some inferences that you're drawing, even if it's the fact that, those white shapes you see in the sky are clouds, that is an inference, but courts sometimes try to draw a line between inferences that are sort of more automatic and less involved. But nevertheless, this is a distinction that does play out in practice. Sometimes it's easy, sometimes it's hard to draw. More importantly, if you're dealing with opinion testimony, the question arises whether it is lay testimony or expert testimony. The key issue here being that you need to be qualified as an expert under rules that I'll describe in a minute if it's considered to be expert testimony. The key distinctions here are drawn in two of the federal rules of evidence, 701 and 702. The key point for Rule 701, which is about lay testimony, is that is the last one here, which is that it is not based on scientific, technical, or other specialized knowledge. So if it is based on that kind of knowledge, then you're in the world of expert testimony. And so Rule 702 talks about what it means to be expert testimony, and then to be able to offer expert opinion testimony, you have to be qualified by knowledge, skill, experience, training, or education. And then it goes through some of the requirements. So it has to be based on sufficient facts, data, has to be the product of reliable principles and methods, and then you have to reliably apply those principles and methods. One key point from those requirements is that if something is considered to be expert testimony, then the standards to qualify as expert testimony will apply both to the underlying data collection methods that you've used and to the interpretation of the data that you're offering in court. On the next couple of slides, I just offer a few examples of cases where the courts have accepted testimony about environmental violations, and they've accepted it as lay testimony. They have not considered it to be testimony that needs to be offered by an expert. And I'm just going to talk through very briefly two of these, the ones on this slide, and I'll skip over the next ones, which are largely similar. The first case I mentioned here, the Ellis case, this was a case where some farmers in Kentucky sued industrial facilities located near their farm, two facilities. These facilities were emitting dust that ended up on the farmers' properties, which led to a variety of harms, including respiratory problems for the farmers and their families. To prove these violations, the farmers did a few things. They took photos of the dust crossing the plant's property lines. They also testified about the dust landing on their property. And they also testified about the fact they could tell apart the dust between the two plants because one plant emitted dust that was red and the other plant emitted dust that was gray. I mean, the court allowed all this testimony in as just lay opinion testimony. They did not need to qualify as experts to be able to offer that testimony. Similarly, in the state of Georgia case, there was some eyewitness testimony about raw sewage overflowing out of a manhole and then flowing into a stream. The defense in this case explicitly argued that the witnesses would need to qualify as experts to offer the opinion that the stuff they saw coming out of the manhole was in fact raw sewage. The court rejected that argument. And similarly, in the next case on the next slide, a couple of cases involving manure that was at concentrated animal feeding operations, manure flowing off of application fields and into water. Again, the courts allowed in eyewitness testimony about the fact that that it was manure and about the fact that they had observed it going from fields and into waters. The court accepted all of that without requiring them to qualify as experts. Really, the pattern here is that these are visible pollutants or well-known odors. These are things that the court will accept that ordinary people can identify and testify about. Conversely, a court is more likely to say you need to be an expert if you're talking about things like samples taken to measure invisible pollutants, or more technical or complex methods of observing pollution. So, for example, in that consolidated environmental management case that I mentioned earlier, in addition to the hearsay issue, there was also an issue about whether the observers, if they testified directly about their observations, if they needed to be qualified as experts, and the court said that they did. And in particular, what the court looked at was that this was an EPA certified method of making these observations. It was technically complex. You had to go through training to be able to make those observations, and then you need to be certified as an observer after going through this EPA training. And so the court said, based on all of that, you needed to be qualified as an expert to be able to offer those opinions. So if you do need to be qualified as an expert, what does that mean? Well, the basic test that the federal courts apply, and most state courts also apply, is something called the Daubert test, which name comes from a Supreme Court case. And there are four factors, non-exclusive, but the four main factors that courts look at to decide whether you are in fact qualified as an expert. These include whether the underlying methodology has been tested, peer-reviewed, or published, whether there is what the known or potential rate of error is for your methodology, whether there are standards controlling the operation of that methodology, and then whether it is generally accepted in the relevant scientific community. A couple of things to mention about Daubert in the context of citizen science. The first key point, which is reflected in this quote from the Seventh Circuit decision, is that you do not necessarily need any particular academic qualifications to offer expert testimony. So just because a certain kind of testimony based on citizen data gathering is considered to be expert testimony doesn't necessarily mean that the citizen group needs to hire a professional scientist to carry out the sampling or to testify about it. It's not necessarily, you don't necessarily need those professional qualifications. It's possible that you can be qualified based on experience or other kinds of training or just other kinds of knowledge and skills. You don't need the formal education necessarily. So if that's the case, then what would it look like if you had non-professional scientist data being offered? I'll just very briefly sketch out how it might look to apply the Daubert factors to citizen science. These issues have not yet been addressed in litigation, so this is all very tentative. I will say one big overarching issue is whether courts, in applying Daubert to citizen science, whether they will look really narrowly at the specific methodologies being used by the citizen group, or whether they'll sort of look at it more broadly and say, address sort of the validity of citizen science in general. And if the courts take the latter approach, then it's going to be harder, I think, in general, to get the data accepted. So if we look at the first factor, whether the methods have been tested, well, it's, if the citizen group is using a well-established methodology, then this is not likely to be a problem. But it really depends on how standard or established the methodology they're using for their data collection. If you look at rate of error, in general, again, it should be possible to establish what the rate of error is if the citizen group is using a standard methodology. One big question here is if citizen groups are using new low-cost air sensors to do air sampling, whether the court would consider those reliable enough or whether they'd be considered at too high a rate of error. If you go to whether they're generally accepted standards, again, following a standard methodology such as a quality assurance protection plan, a QAPP, that sort of thing would be more likely to ensure that you will be considered following general standards. And then finally, whether something is generally accepted in the scientific community. Really, the question, this is where it really becomes important whether the court is looking at this broadly or narrowly, because I think it's still somewhat of an open question whether the professional scientific community accepts citizen science as being, generally accepted as a reliable methodology or not. And so perhaps there's a higher risk there. Now, I just briefly touch on some suggested practices for citizen groups and then also for agencies and the scientific community more broadly to help make it more likely that citizens' data can be accepted in litigation. For the community groups themselves, I would say, you're more likely under the Daubert test to get your data accepted if you train your volunteers, if you are documenting all of your activities, and if you follow some other standard quality assurance, quality control protocol. And I'd say that in all of these, one thing reference that is helpful for all of them is a document that was just recently issued by EPA called the Citizen Science Quality Assurance and Documentation Handbook. It has some standard forms you can use, so it can be quite helpful if you want to, establish your project according to these standards. Now, none of this guarantees that the court's going to accept it. Again, this hasn't been tested, but to the extent you're following a standard methodology that's been established by EPA, I think you're more likely to be able to check each of those boxes in the Daubert test. And then finally, I mentioned the rate of error in low-cost air sensors as being an issue. I would say that, try to use air sensors that have scored well in tests that are being carried out by California's South Coast Air Quality Monitoring District. They are in the process of testing low-quality air sensors, so certainly if you get ones that are relatively high scoring there, you're more likely to be accepted into court. And then looking beyond the citizen groups, I think, certainly more work by agencies to develop regulatory benchmarks for sensors is helpful. EPA and California are working on this right now, and so continuing that process would certainly help. And then on that last factor in Daubert, certainly this, the more widely accepted citizen science becomes in the scientific community, the easier it'll be for citizen science to be accepted in court for enforcement purposes. And then with that, I will wrap up. I have my contact information there if people have questions or would otherwise like to follow up with me after this. Thank you.
Thank you, Sean. I might point out that actually the Citizen Science Association legal working group has got a call this afternoon, I believe. And George Wyeth,
That's right. Yeah.
who helped organize that group, is here in the room with us. So George, thanks for your work in that area. Our last speaker is a substitute from the Public Lab organization, and that is Stevie Lewis, who came to Public Labs with a background in environmental studies and community development. She's held positions as volunteer coordinator for the Grand Bay National Estuary Research Reserve in Mississippi, resource advisor for the National Park Service in response to the Deepwater Horizon oil spill, and as a watershed coordinator for the Alliance for Aquatic Resource Monitoring, a nonprofit focused on promoting citizen science in aquatics. Stevie's interest in building community resilience through environmental initiatives include community and environmental work in far-reaching corners of Kenya, Thailand, Botswana, and Scotland. Welcome, Stevie.
Thank you very much. Can you hear me?
Yes, we can.
Okay, great. So I'm Stevie Lewis. I work as Outreach Director of Public Lab, which is a nonprofit which supports a large open community of people that are interested in applying open source technology to support environmental challenges. I just want to check my slides here real quick. Okay, great, perfect. Shannon, unfortunately, is unable to join us this morning. I will be using her slides, but in lieu of her intro to how she came to Public Lab, I will substitute my own. So just bear with me a little bit as I compare and work a little bit through her slides and some of my story as well. So the work of Public Lab was largely influenced in early days by a small organization in Louisiana, Louisiana Bucket Brigade, that worked on setting up community monitoring programs for fence-line communities, which neighbor major oil and gas refineries across Louisiana. They have a tendency to send out their emissions in the middle of the night, which is referred to as the midnight sun, because even from far away, they look like a massive fire. So in thinking about that in the background, my story in getting to Public Lab, as you have mentioned earlier, I was working at a research reserve in Mississippi. At the moment of the BP oil spill, the research reserve essentially had to shut the doors, a public facility, to people in terms of understanding and what was going on in the Gulf Coast. So public facility was unable to essentially answer to what was going on in the Gulf of Mexico in relationship to the spill and how that was affecting the communities. There was, I think, a lot of people know, in the time of the spill, the response was put into the incident command system, where information was transferred basically up and down, and not a lot was transferred out to people in the communities that the spill was largely affecting. In contrast to my experience working at the research reserve, where the information channels were largely closed, a group of people in Louisiana were getting together and drawing from people with interests and concerns across the US and across the world on how can we document the incident and share out about the effects of it on the Gulf Coast. So this group of people gathered together simple technologies and tools to visually document the spill using balloons, kites, and cameras to capture images of the oil spill. So essentially you can see here, there's the kite, and then the camera is attached to the kite. Basically your very low cost and early 2010 version and very inexpensive version of what a lot of people are using drones for these days. These images really did capture a lot of what was going on the ground, thousands of them from across the Gulf Coast, really capturing high resolution images where, in collaboration with people, as I mentioned, from across the US and around the world, we're able to work together to build a platform that allowed people to take the images from the Gulf Coast and stitch them into maps that are geo-referenced and laid over on Google Earth. So really capturing the real-time data. So this really sparked a lot of Public Lab's initial gathering moment, where we're really talking about increasing accessibility for people to talk about the environmental issues that are happening in their backyards, affecting their health, their human health. So the work of Public Lab was, after the oil spill, we began to think about the complexity of environmental pollution challenges that people face, and wanted to address the lack of access to tools and methodology and the top-down nature of the scientific process. So we modeled Public Lab to think about systems that are receptive to grassroots and ground-up citizen data collection. Arising from the spill, Public Lab's work now ranges from Louisiana to refugee camps in Lebanon to environmental justice corridors in China, and supporting groups doing mapping and projects in India. Our model is to entrench equity and access in all parts of the environmental exploration and advocacy processes. Practically, this means removing barriers to access by simple means, such as reducing jargon, so that people across expertise can more easily communicate, and using simple technologies, especially those that produce data which appeal to our human senses, to explore and share about environmental issues. So Public Lab is built by people for people, and from this we use the power of a vast network to break down and understand environmental topics. We're also conscious of how this work is situated in the complex political, social, and cultural landscapes around us. Across the spectrum, we're attempting to change how scientists and other professionals think about collaboration, making room for people to create stronger, more people-centered science. But this isn't easy, and citizen and community science have been growing forces over the last decade, hand in hand with the age of crowdsourcing, crisis mapping, and Gov 2.0. Our executive director, Shannon, became a NASAP council member in 2016 when the council was charged with identifying ways the EPA could incorporate citizen science programming to both support the agency and to think about ways in which the agency can be more supportive of communities that have environmental questions. The council, with broad support from citizen and community science world, came up with a series of 4 top recommendations and sub-recommendations, but taking action on these has been, unsurprisingly, has been complicated. The places where the EPA, where we've seen the most willingness to change, for instance, as was mentioned in the last presentation, was in the new preparedness guidelines the EPA prepared, but we've seen little to no movement in other areas. I think this means that we have to be willing to think about structure and impact differently than just data leading to enforcement, encouraging agencies to look at the value of community collected data beyond regulation, enforcement, and gap filling. One of the most interesting to me has been in the collaborative governance. What can happen when the knowledge of decision-making is spread across a community rather than located solely within a government office? This isn't about data for enforcement, but it's about facilitation, relationship building, and figuring out how the rich flow of data can make decisions stronger for people who they will most affect. One of the most important things that came from this report was the recommendation about how citizen data can work across different pieces of the puzzle that sometimes data initially collected on the far left of the spectrum can down the line contribute to something on the far right. As we've seen as we think about impact, we should be considering the moments in which a single data point or a pattern that is determined by years of dedicated observation can start the ball rolling on environmental management and enforcement activities. So a good example of this sort of snowball effect, where one image can help to communicate the complexity of an issue and can lead to something much bigger. Back in Louisiana, to document visible violations of operation permits, one group again flew a kite. Through this aerial photography, and the coalition was able to capture compelling data that demonstrated the polluting facility activities. The photographic data was able to prompt a consent decree from the Louisiana Department of Environmental Quality, including fines of $16,000. Or sorry, $16,000. Unhappy with the terms of this decree, the coalition, working to collect this data, approached the Tulane University Environmental Law Clinic to sue United Bulk under the citizen suit provision of the Clean Water Act. And in 2015, the suit was settled for stricter pollution prevention terms, further containment and cleanup activities of the United Bulk, and additional fines of $75,000, which have benefited the Woodland Conservancy to restore wetlands and forest felled by Hurricane Katrina. So Scott Eustace, a wetland specialist for formerly GRN, now Healthy Gulf, has called the use of this data a critical turning point in our understanding of the problems with United Bulk's dock. With the kite, we saw very close the slide view of this for the first time. The pile accumulating beneath the conveyor showed that the conveyor was moving material directly into the river over multiple days. The accumulation of this to form a pile showed that there was a systematic problem related to their equipment and not just a fluke or a shift worker or the wind. So we have a number of challenges across the work that we're doing. One, community building can sometimes be like walking on an ice-covered lake, which is quite delicate and has to progress slowly. Trust is built when there are cracks that start showing. They need to be resolved rapidly. Two, science industry has far greater capacity to create and generate data and thus drive much of the dialogue. Researchers have difficult time accepting expertise that comes with deep knowledge of a place and experience in a place that oftentimes people hold. And three, technology. There is no silver bullet applications or technologies that can be put forth to do the work. Technology has to be wrapped in social, cultural, historical, and political contexts, and often then even times may fail. But here are some of the lessons that we've learned over time that can be helpful. Build relationships based on equity from the beginning. Honor different types of expertise, local knowledge and experience, and consider the places where collaboration can happen. Leverage scientific knowledge to help distribute power, and think critically about the use of terms such as inclusion and empowerment. Co-opting people and their work can create friction. And move beyond feedback loops and step into solution finding. And finally, address tech solutionism before it becomes a problem. So that's it for the slides that I have today. Thank you so much for your time, and I will be around as well if anybody has questions after.
Great, thank you. I'd point out that when we were working on our citizen science paper, the two NACEP reports were critically important, and those are excellent resources for anyone who wants to look into the policy related issues. Really a good resource. It's my understanding that if you have questions online, you can send them in to us. So we're going to start our question session. I have a couple questions to start with, and then we'll take questions either from those folks online or the people here. And John, I was wondering, you talked about using the false claims statutes as an enforcement tool, which of course has to implicate government activity. In some of these cases, especially wildlife, there are materials marketed to folks. do consumer protection, consumer fraud laws have a role potentially to play? And that's often at the state level, not necessarily at the federal level, although FTC could be involved.
Yes, there are some consumer protection laws. There aren't many that explicitly provide rewards. I'm not aware of one at the state level, but it's worth taking a look. Again, recommend taking a look at the handbook. It gets a whole chapter on that subject. The other thing is like consumers are also being marketed to by companies through their disclosures. So the law we really want to call people's attention to is the Dodd-Frank Act, which regulates public statements by any publicly traded company, not just to shareholders, but to potential shareholders, which is the public. So anything misleading coming out of a publicly traded company is a potential Dodd-Frank violation, which has a very significant whistleblower reward provision.
Great. And Sean, I had kind of an initial question for you. When we were doing our case studies for the citizen science paper, one of the things that was notable is that most of the citizen groups were working with university or other experts. And it seemed to me that, at least in this small sample of 10 case studies, that DAWBEAR probably would not be a tremendous barrier because there was either QA/QC involved or experts who might qualify. Do you have any thoughts about that?
Yes, no, certainly that is the more standard practice now. As you saw in your paper, which I really thought was an excellent paper, I think that's obviously if you're bringing litigation, you want, it's a lot of work and investment that goes into that, and you want to play it safe. And so the practice has been to work with professional or academic scientists. And that certainly is the safer approach. Now, the point that I was trying to highlight was that, it's not necessarily the case that you need to do that. Now, it hasn't been tested in the courts, and there's uncertainty there, and there's risk associated with not having professional scientists, and so understandably many groups are not going to want to do that. But I was trying to suggest that I think there is room for the argument that you could have well-trained non-professional scientists who are operating under standardized methodologies, and that data could be considered reliable enough. But I think there's still work to be done, and certainly there are things that state agencies and that others can do to try to make it easier for citizen groups to know what kinds of standard methodologies they should be using, and certainly to the extent that if agencies themselves become more willing to accept citizen data in more contexts for their regulatory decisions, then I think that would provide comfort for the courts to make them more likely to accept that kind of data in litigation as well.
Right. And Stevie, I was wondering whether your organization has looked at how the data that might be gathered by citizens, rather than affecting public governance, may affect private governance, with more companies having their own environmental governance systems and worrying about their suppliers, or even just knowing what their own emissions are. Have you seen a role through Public Lab in just providing better data to emitting facilities, either through their suppliers or their own facilities?
Yeah, that's a great point, and I think there are some good examples of where community collected data can help to open the doors of conversations between people who live by industry. For example, we have been working for a number of years with community groups in the Wisconsin area who are affected by the frac sand mining industry, and for those who don't know, the frac sand is what's used as the proppant to hold open the fissures in the fracking process. And the sand itself is extracted in various places around the US, but especially in the Wisconsin area for its how round and fine it is. For this process itself. And the example here that I'm getting to is that the community groups or communities that are living by a lot of these have over time really been affected a lot by some of the particulate matter pollution coming from the extractive industries of sand. And the collection of, over many years, I think the conversation has been sort of at a standstill around where, the pollution that is happening. But the One Community Group's work with the Purple Air Monitor has really helped to open the conversation about the realness of the particulate matter pollution and its effect on the community groups nearby. So there's, in this one particular example, there's a communication channels that have been opened between people based on the results that we're seeing from the local purple air use. To be able to call the facility and talk to them and say, hey, we're really seeing some increases in the particulate matter pollution today, what's going on? And in turn, the responses from the facility to say, hey, oh, we really do have something going on here. Let's see what we can change and if there's a system that needs to be addressed. I think that's one example of, let's talk about open data and let's talk about when everyone can see the results of what's coming through. In this particular example, the purple air data is shared broadly online, and anybody can go on and view this at one time. It's not behind some closed doors, and it doesn't need to be processed in a lab. And that kind of transparency around environmental pollution can really, I think, help to elevate these conversations and make them more public.
Do we have questions from members of the audience? Yes, right here.
Sean, this might be kind of a,
You have to use the mic so that we can pick up.
To John, this might be sort of a more fiddly legal issue, but are there concerns if you're turning these whistleblower laws against environmental crimes with preemption under the environmental statutes? A judge might say, no, you have to use the citizen suit provisions to go after this?
No, I'm not too concerned. I think that the two provisions sit nicely together. Typically, whistleblower provisions are designed to help government build their cases, whereas the citizen suit provisions oftentimes are combined with the Administrative Procedure Act to challenge governmental actions. So the only closed cases might be where, for example, Clean Air Act calls for direct enforcement against an emitter, but there really isn't a whistleblower provision there anyway. So I'm not aware of any conflicts.
Another question, row back.
Hi, I guess this is also for John. How important do you think financial incentives are for people to bring forth like a whistleblower claim?
I'm sorry, can you repeat the question?
How important are like financial incentives
for
people to come forward, do you think?
I think they're critical. The question was about financial incentives. There have been some surveys done of whistleblowers, and it is not often the first reason people step forward. People typically step forward out of a sense of wanting to address wrongdoing that they are directly exposed to. But there is a risk-reward calculus. As people see some of the ways that whistleblowers' lives have been upturned and made much more difficult as a result of stepping forward, there are many people that are skeptical of whether it's worth the trouble. So to have that as part of the conversation, like for example, you may not be able to keep your job in this industry. Would people be willing to sacrifice that in order to step forward and do justice? Some might, but the fact that there potentially is a reward on the other could be the factor that tips that calculus. And so in our view, the reward system is fundamental. In fact, there's a number of places where the only whistleblower protection is against retaliation, but there is no financial benefit whatsoever. That's the case in most countries around the world where there is any whistleblower protection at all. It's largely just against retaliation. And you don't see the volume of people stepping forward and helping out on cases.
George?
Hi, thanks. I've got a question for Sean. I'm a little surprised that there don't seem to be more reported cases involving examples of what we think of as citizen science. The examples you gave were really, I mean, they were cases involving citizens providing evidence. As I recall, there were more, it was more just direct observation, the kind of thing that was probably part of traditional citizen suit cases. Do you have any thoughts on why we don't see more cases directly addressing issues of admissibility using new air sensors or other forms of what we think of as like really more advanced forms of citizen science?
Yeah. So hi, George. This is certainly something that's puzzled us in our research. We were expecting to find cases that really address this directly, and we're really struggling to find them. Now, it's possible that it's just that we're unsuccessful in training them up because we did find it hard to think of what the right search terms would be to focus on those kinds of cases, and so it's possible there are some out there that we missed. I think more generally, it's probably a function of a couple phenomena. One is just that environmental cases, as with most litigation, the vast majority of cases settle, and so we certainly heard of examples of cases that were brought based on citizen science data, but just settled without a court decision. So there's no ruling that comes out in that case about whether the data was admissible or what weight it would carry. And then the second is what we talked about just a few minutes ago, which is that to be safe, most environmental groups in the bringing cases will retain a professional scientist or an academic scientist as an expert, and therefore they avoid some of these questions that way.
Right.
So I have a question. I think that's primarily for Sean and Stevie. We've seen a few states, certainly in what are called ag-gag laws, which prevent gathering data related to animal practices, but we've got at least I think one or two states that have adopted data trespass laws. I think that was Wyoming being one of those. That thus far the federal appellate courts have not upheld. They've overturned those on First Amendment grounds because they saw gathering information as preparatory to speech. What do you see from your organization's standpoint about where states are going with these kinds of laws and what kind of danger they may present to citizen science as we go forward?
I guess I can go first. This is Sean. I'll just say that we did survey those kinds of laws for our manual, and so we certainly found a large number of ag-gag laws, which take many different forms. I think the advocates of those laws have been trying out different ways of framing them to try to design them to overcome First Amendment claims. But thus far, the cases that have been litigated, they've been unsuccessful. The courts that have reviewed them have generally found them to violate the First Amendment. And then for data trespass, the only law that we're aware of that sort of really directly takes that approach is the Wyoming law. We haven't seen other examples since Wyoming passed that law several years ago. I think the ag-gag laws will definitely see more of those coming. I think that the main target of those has been animal rights, animal welfare activists. I think they sort of what we think of as being environmental citizen science gets kind of swept in maybe not exactly inadvertently, but it's not the primary focus of it. Whereas, the data trespass law in Wyoming was really the first law we saw that very directly and specifically was targeting environmental citizen science. I don't know if we're going to see more laws like that. I'll just say with respect to the Wyoming law, there was a court decision striking it down in part on First Amendment grounds, but part of that law is still in effect. The part of the law that provides that says that you will be face stiffer penalties for trespass if you are on private property and your purpose is to collect resource data. You can actually, under Wyoming law, you can face a stiffer penalty for trespassing on private property for that purpose than you can if you're trespassing for other purposes. That it would seem to me that really should also be a violation of the First Amendment, but that part is still in effect. The courts have not struck that part down yet. So I don't know if the fact that part is still in effect is going to embolden people to try to pass these laws elsewhere. But that law, it was really the passage of that law that got our clinic interested in working on citizen science issues in the first place. So that was the trigger for us, because we were surprised to see something that so directly targeted citizen science.
Stevie, do you have any thoughts?
Yeah, I think, it was definitely a moment that I remember a few years back. And it is a big risk when we're talking about restricting people's access to collecting data and information. And any ways that we can work to make sure that those things don't come into law, I think is a really fruitful practice. But one of the things around that is really there are opportunities otherwise if you're operating in a system like that, where public spaces are accessible for people to collect some of this information. And this is what we've seen a lot with people in public lab, is even though you're dealing with private property spaces, environmental pollution doesn't stop at the boundary of private property. And it is in some cases available to collect data and information about a pollution event from a public space about something that's even happening on a private property. It certainly does make it more challenging when there are restrictions around that, but I think that we have to be able to work and operate within the bounds of our legal system, and thinking of ways around that is really important. I think another risk to think about in terms of people's ability to advocate and to talk about in local environmental health is the risks that we see where states especially are working to remove local control of permitting processes. I think that's a big risk when we're talking about people's access and ability to advocate for their environmental health. We've seen this in some states. It's moving forward as something that is a movement from industry, is to really take away the permitting process from local authorities. And other states are really working hard to entrench those practices within their culture of adding more local control of some of the permitting related issues.
So one related issue to public space is airspace. And I believe Texas has a law that prohibits drone overflights of critical infrastructure. On one side, you could see that as a security measure to prevent potential sabotage or other kinds of activities. On the other side, you could see that as a way of preventing citizen monitoring from public airspace, assuming the drone is in public airspace, of things like methane emissions. So any thoughts on those kinds of issues, drones in general, or the kind of Texas law that I just mentioned?
This is John, I'll go first. This new wave of technology, obviously there are some downsides, but it's really critical for advancing the cause of citizen engagement on our environmental laws. Drones are transformative for identifying violations. I would also add just the basic smartphone. There are plenty of people we actually have in our network who are collecting data of, for example, ocean dumping. That's great evidence if you've got a live video straight off your smartphone. I think we all need to fight tooth and nail to protect the citizens' ability to use these technologies when they're in public space.
Sean, any thoughts from your side?
Yeah, so I'll say critical infrastructure laws, that's another category of laws that we reviewed for our manual. And I think there are a couple of types of issues there. One is, with the nature of the restrictions regarding activities near critical infrastructure. Certainly, preventing you from using drones in public airspace is a concern, certainly to the extent that they get beyond trespass and start trying to encompass activities near the boundaries. Then that's also a problem for other kinds of data collection near the private property. And then the second category of issue is really, which kinds of facilities get defined as critical infrastructure. I think even within kind of the core definition of what would be critical infrastructure, you would often find things like power plants and oil refineries, which are exactly the kinds of facilities that citizen groups would be concerned about because of their pollution, but then also sometimes other kinds of things get thrown in there because of industry advocacy. So you mentioned Texas. Texas, in its definition of critical infrastructure, includes confined animal feeding operations. And those are defined as critical infrastructure in Texas. And obviously those are major sources of pollution concern. And really, I would think from a concern about, public infrastructure, those are not the kinds of facilities that should be considered critical infrastructure. But so by defining them that way, they are in fact, directly inhibiting attempts to monitor pollution from major pollution sources.
Stevie, any thoughts?
Yeah, so a lot of these technologies are newer that we're talking about right now, drones, some of the air monitoring tools that have come out in the last few years. But I think one of the things that's really important to keep in mind is that access to talking about your environmental health and the problems that might stem from a polluting industry, there are ways to think around it. Like we clearly, seen a public labs example of using balloons and kites to map. We're talking about reducing barriers around monitoring. So if you can take something that, like, if we were talking, you can talk about it from a situation where you're talking about the restrictions, but there are also opportunities. And similar to my last answer, where you're talking about being able to monitor from still a public space, where you can't use a drone to map something, you can still use a balloon and kite. They're federally classified as toys. The other thing that's interesting about it is when you use something like that, you're really tying yourself to the data. You're not, you can pull the balloon back in, you're connected on a string. Somebody can come and talk to you about what you're doing and why you're doing it. So I think, like, the more we can increase and the repertoire of things that people can use as tools to collect data is great. But we shouldn't, I think that we can still look at opportunities within some of the restrictions that we see and think creatively around it. And creative thinking with a lot of people in the room can be really powerful.
Great. John, I had another question. Since this is a INEAS related meeting, question of training and what kind of training is needed both here in the US but around the world on whistleblower involvement, facilitation, design of whistleblower statutes. Do you have some thoughts about that?
Yeah, thanks, Lee, because I do think that is one of the critical needs. Even just among my friends who, a lot of them pay a lot of attention to the environment and pay attention to environmental laws, fairly poor understanding of our body of whistleblower laws here in this country. And then as you travel abroad, and I have been trying to talk to as many people abroad as possible, the fact that a non-US citizen based outside the US, battling some company that's based outside the US could actually take advantage of a US whistleblower laws is virtually unknown. The benefits US whistleblower laws have delivered is virtually unknown, and therefore very little momentum in most countries' legislatures to replicating. There is, again, to be a little bit repetitive with my presentation, probably not enough conversation even among the sophisticated international NGOs about how to gather this information in a way that protects people. And there's a lot of new apps on smartphones, for example. They're not encrypted information. People collecting information and submitting it are essentially serving as whistleblowers, but may not even be aware of the whistleblowers, and may not be aware, one, of the benefits of the rewards they might be able to collect, but more importantly, the risks they're taking about using non-encrypted technologies. So I just think we have an enormous task in front of us to train citizens, NGOs who are connected to citizens, on both the legal and the technological aspects of this.
Yes.
Just had a question that kind of builds on that. That was from an online participant who was asking specifically about how we get citizen science and citizen involvement initiatives going in developing countries specifically.
Yeah, I do think it's important to give some focus there. This is John again, because of the fact that as you get into countries that have weak governance structures, the risk of being an advocate go up dramatically. And so whatever strategies we might design here in the States for engaging citizens need to be almost put aside, and we need to develop country-specific strategies where going to your local law enforcement increases your risk rather than is a form of moving forward with your case. So I think there is a lot of services we can deliver just from an equity perspective to think about people who want to help their communities, need help to advocate in a way that is safe. There is a big question for a lot of people whether they could even stay in their own community if they participate in advocacy. And so none of us from Washington, D.C. are going to be qualified to answer that. We need, local NGOs, civil society organizations to be involved in this conversation to help work through these challenges, help us understand which local officials are corrupt and which are not, and where it's safe and how it's safe to participate.
We've got a couple minutes left, right? So I've got one other question that I'm particularly interested in, and we've talked a lot about monitoring side of things. I'm wondering, especially with Stevie and Sean, whether you have some thoughts on the kind of the big data and data analytics. So as we gather more of this information, are there mechanisms, especially in the public lab side, for accumulating the information, analyzing it in different ways, especially not having to rely on government for the analytics side of things? Stevie, any thoughts?
Yeah, I think there are a lot of tools and resources available now to help people think about and process data. But I think, in terms of one of the things that's really important to me with Public Lab and with working with people on this is you can go about collecting a bunch of data, and that can be great and helpful. But if you're not answering your initial question of what the problem is, or trying to get to your keeping your advocacy and your goals and objectives in mind is really important. So we're not doing science for the sake of science here. We're not working to gather as much data as possible. We're working to gather the data that's important for our solutions. So there are a lot of tools and resources available for people to think about using different kinds of data. I'm really personally interested as well in data that's visual, and data that we produce that can share with audio outputs and communicate with people in different kinds of ways. And there are a lot of resources out there now around that, and changing the way that data can be told through different types of stories. And ultimately, I think that protecting the existing data that's there is something that has been really important in the past, specifically 3 years or so. One of the things that we've seen come since our last election cycle was the Environmental Data and Governance Initiative, working to protect the data that is existing in the government. So, and making sure that that's backed up in a place that's not just hosted on a website that can be changed, but is actually owned and managed by the public and where there's public access. So, just I guess in twofold, like protecting the data that's currently there, and then really making sure that in your community science or citizen science projects, you're gathering the data that's important for your advocacy outcome.
Great. Well, to be our last word, let's thank our panelists for an excellent presentation today. Good afternoon, everyone.